Our next speaker is Will Homiller, and he's with Troutman Sanders, one of those law firms that took advantage of the computers to save their clients money. I can't help myself, I'm sorry. Will helps landowners, developers, other local regional clients in the financing of commercial property and the development, the redevelopment. It's gotten so much more complicated. And it's not just, it's the regulatory environment, it's the environmental issues, it's the financing issues, it's across the board, it's gotten complicated. I don't know if that's a necessity, but that's certainly the case. I know this, whatever you're doing in life, you have to be more, it's much more focused on your liability. And that's part of the reason you have lawyers help you not get ahead of yourself. Protect me is the word I would say. So, Will, would you come up here and give us your insight? Thank you, sir.
First of all, thank you everyone here and everyone at Commonwealth Commercial for having me, giving me the opportunity to speak with you today. My name is Will Homiller. I'm an attorney with Troutman Sanders, and as Sidney mentioned, it's in your materials. Troutman Sanders is a large law firm with attorneys around the globe. We handle all matters of legal representation, consider ourselves a full-service firm. I work in the commercial real estate group, and as Sidney mentioned, I primarily help local and regional landowners and developers with issues relating to purchase and sale, leasing, finance, zoning, and permitting issues. During my career, I've had the opportunity to work closely with the folks at Commonwealth Commercial. I've always enjoyed being on the team with them on those projects, and I really enjoy being on the team with them today. Real estate in transition. When I heard that topic, the first thing that came to mind, of course, was the economy. It's the economy that's in transition, and it's the economy that we're going to focus on when we're making our business decisions about our real estate investments. And that's all true. The economy is in transition, and hopefully from bad economy to a good economy, and continues on that path. But in many ways, we need to think about the way that real estate law is in transition, because the legal framework in which you make your business decisions is constantly in flux, and it's something that you need to focus on as well as the economy. Go with the slide here. All right, so in many ways, real estate law is not in transition. It's fairly static. As I learned when I was a first year in law school and sat down with my property textbook for the first time, cracked it open and thought I was going to read about how to become a real estate attorney, quickly realized that wasn't the case. I was going to be learning about Old English common law and Old English statutory law. And there was good reason for that. It's because the real estate law that we know and love today has its roots and foundations in ye olde England. Just by way of example, I was reading recently an article about the history of the purchase and sale agreement. It's not recommended reading, but the point that I got from it was that the division of equitable and legal title that results from our modern day real estate purchase agreement actually has its roots in a statute that was passed in England in 1535 during King Henry VIII's reign, called the Statute of Uses. And I thought that was interesting, not so much the statute itself, but the fact that this basic principle of a purchase and sale agreement that we use every day actually has roots that are nearly 500 years old. So that's one perspective how real estate law is not really in transition, but in many ways real estate law is always in transition. The best evidence of this is looking at the Virginia General Assembly. Recently received a packet of information from the Virginia Bar Association, and in it was a summary of all the legislation in the past General Assembly session, 2013 session, that related to real estate. And in the front of the materials was a list of all of the bills that were passed that related to real estate. I'm flipping through, looking at the materials, thinking, how does this affect my practice? And I started counting. There actually were 57 bills passed in the General Assembly that relate to real estate, just this past session. That's 57 changes to the Virginia Code that could have an impact on your decision-making with respect to your real estate investments. And that's just the Virginia Code. That's just one source of law that we're talking about. You've got local ordinances, especially zoning ordinances, that are constantly changing. You've got tax codes that are changing. You've got environmental regulations that are being interpreted one way or the other, always changing. So in many ways, real estate law is in transition. It's up to us to try to identify how it's in transition and where it's going. We don't have time today to run through all the different ways that real estate law is in transition, so what I thought we'd do instead was step into the shoes of a couple of decision makers, owners of property who are facing decisions that you and I might be facing in our work, and see how these certain real estate law trends influence their decisions now and going forward. And the two main trends I want to focus on are the transfer of development rights from rural properties to more developable properties in concentrated urban and suburban areas, and what I like to call hands-on zoning. The approach by localities these days to expect more specificity in what's brought to the table when they approve rezonings. All right, so our first set of decision makers are the Walton family. They may be like the Gray family once upon a time. We don't know. They have a family farm. They don't have the same aspirations as the Gray family, though. They have no plans to develop their farm. They live way out in the west part of the state. They have several hundred, maybe 1,000 acres, and they're content having their family farm, doing a little foresting activity, and they intend to hold this asset for the long term. As Bill was mentioning, it's important to have a team these days, and so the Waltons have assembled their own team. They start with Commonwealth land, of course, for obvious reasons. They need to keep their lending options open, so they keep the Xenith Bank on their Rolodex. JoycePayne Partners is going to help them diversify their assets, and since it's my slide, I get to pick their legal counsel. So here is kind of an overhead shot of the Walton family farm, crudely drawn by me. We've got the yellow areas there are supposed to be roads, and the bright blue squiggly lines are intended to represent a stream or some kind of wetland area. Since the Waltons don't really want to develop this property, they want to continue to use it as a farm. There are fairly limited options as to how they can realize value from their property in addition to their farming activities or their foresting activities without doing major change to the landscape. It looks like even at this stage of things, where's my pointer, they may have even sold off the lots along here, which is pretty common to homeowners who build little houses right along the roadway there. They don't want to do that anymore. They don't want to break up the land. They want to preserve the integrity of the land. So what developments of law are there that give them the opportunity to realize some value from these properties? The first that I'd like to mention is the conservation easement. What is a conservation easement? I think we're all fairly familiar with the concept. It's an easement where the owner of rural property, typically rural property, agrees not to subdivide his property any further and to restrict certain kinds of development, primarily commercial and high-density residential. In exchange, they realize benefits from tax advantages. Conservation easements are in place and are an invention of the law that seems to benefit everyone, or at least they're intended to. The public benefits from having resources protected, scenic views protected. In some ways, it fights suburban sprawl. It can help localities control costs of infrastructure if you don't have neighborhoods popping up all over the map. And it also obviously helps the landowners themselves because of the tax advantages. So for the Waltons, is this a viable option? And I think it might be. How would the Waltons qualify is the first question. They have a farm. It's got scenic views. It's got open space. It's got agricultural uses. It's got forest uses. These are all types of uses that would be compatible with a conservation easement. Next question is it worth their while? And this is a big key in whether or not they pursue a conservation easement. They must get an appraisal, and there's some trickiness to the appraisal process that, again, you need to rely on your team to help figure out. But basically what they want to do is give some sort of value to the easement that they would be conveying. And just to be clear, the easement that they would convey would be to a land trust or third-party organization like the Virginia Outdoors Foundation. So say the appraisal comes back and it shows that the fair market value of their farm before the easement and then after the easement reveals that the easement itself is of enough value that they want to pursue a conservation easement, then what benefits would they realize from doing this? Well, obviously, the primary benefits are tax incentives. They would see federal income tax deductions based on the value of the easement. Virginia state tax credits are available in certain circumstances. The value of the property as diminished by the conveyance of the easement could result in a reduction in federal estate taxes. And if they're not already enrolled in a land use assessment program, they could see benefits at the local property tax level. How is it done? They would contact one of these outside groups, like the Virginia Outdoors Foundation, who would come to the property, evaluate whether or not it's a fit for the program. If it is, they would engage in discussions about an easement, and the easement document would get recorded. Hopefully they run it by their attorney first. The document does prohibit certain kinds of subdivision and would restrict certain kinds of development. In most cases, though, what the Waltons can do after the document is recorded is generally carry on life the way it had been for them before they signed the easement. So they realize all these tax benefits, but then they continue to farm the land, they continue to forest the land, or timber the land, and there would be certain requirements, best management practices that would be required for those kinds of activities, but on the whole, not much would change. So it seems that a conservation easement would be one viable option for the Walton family. Wetlands mitigation banking is another potential option for them. Wetlands mitigation banking, as you may know, is where the owner of land that has wetlands on it already, in some cases it's just upland, either preserves and creates, or just creates wetlands on their property. And by doing so, they generate credits that they can then sell to developers in more concentrated developable areas that buy those credits and can help shortcut the development process on those more highly concentrated sites. Again, it's another one of these everyone wins scenarios, or it's intended to be. There's a public benefit and there's a private benefit. Question is, would the Waltons qualify here? Well, they've got, it looks like, the right natural features for this, but I should caution that it's not always so obvious what land would be eligible for mitigation banking. It's a much more complicated process and not as easy an evaluation as perhaps a conservation easement would be. The Waltons would need to work closely with the mitigation bank review team that's comprised of multiple state agencies. If they do qualify and they want to move forward with the process, they would enter into a mitigation banking instrument, which is called an MBI, and it's one of the more complicated agreements I've run into in my time. Again, working closely with your team of consultants, especially your legal counsel, would be important. There's also an instrument that would be recorded that would put some restrictions on the property for use of the property, protection of the wetlands, that would be similar to the conservation easement. Benefit to the Waltons, of course, they receive credits and they sell them. There's economic benefits from the sale of those credits. And so the next question is, well, they've entered into this arrangement, what can they do now with their land? Well, as long as they're not farming within the wetland areas, they can continue their farming operations. They can continue their timbering operations as long as it does not interfere with the wetlands areas that are protected. But I think an important distinction between these two kinds of programs is that in the wetlands mitigation arena, it's not just restrictions on your land that are put in place, it's also obligations. Obligations put on the landowner to ensure that the wetlands are protected, and where wetlands are being created, ensure that they are created and continue to be protected. So there's sometimes some costs involved in that are wouldn't be anticipated under a conservation easement type of arrangement. So would wetlands mitigation banking work for the Waltons? Maybe. The conservation easement seems like more of a fit. The Waltons don't seem to be interested in creating wetlands as much as they do farming, so they would just need to talk to their advisors about that. The reason I bring up these two kinds of two options for them is because the general trend that they represent is a transfer of development rights, where in these past two cases, it's more of a forfeiture of development rights. What we're seeing as a trend these days, and what the Virginia General Assembly has passed enabling legislation for, is for localities to adopt transfer of development right programs, where rural properties and rural property owners are able to strip their land of development rights and sell them on almost like a free market basis to owners of land in more traditionally developable areas like urban and suburban areas. So far, only Frederick County has adopted a true transfer of development rights program. And just to show you how it works, the properties here in brown and in kind of this yellowy color and green are the properties that are deemed to be sending properties. They are properties that have some sort of rural value to them, either because of natural resources or open space. And the properties in gray here and here and here and elsewhere are considered to be receiving properties. And so in Frederick County, what is the case and what would be the case in other localities as they adopt these programs would be that the owners of the properties in the brown, orange, and green would say, okay, I have the right to build so many dwelling units per acre on my site. I would like to sell that right to the folks down here who are properly zoned, and that would allow the folks over here to increase the density on their site without having to go through a rezoning process. It creates kind of a free market. It's still a bit of in an infancy stage right now, and again, this is the only locality that I know of right now that's adopted this kind of program. Others are talking about it. I think it could be the direction that Virginia is heading and the nation is heading in terms of finding a way to provide economic incentive for the protection of natural resources and open space. What's key here, I think, as a takeaway, is that this may be on the horizon, something to think about going forward if you have rural property that you don't intend to develop. It's more of a hold type situation. If you are already engaged in a conservation easement type of scenario, you may not be eligible for this. So if you're on the fence about conservation easements and your locality is talking seriously about transfer of development rights, you may want to keep that in mind.
What if you want to undo? You've just done this. What if you want to undo it?
Well, if you've done the conservation easement, there is no undoing it. It is perpetual, it's permanent. Transfer of development rights, I believe, is the same way. I'd have to check the specific program. Generally speaking, these are permanent decisions.
So you can't make a mistake.
You cannot make a mistake. All the more important to keep that team of advisors close to you.
I feel better.
Yeah. All right, so on to the next set of decision makers. Here we have Andy and Elizabeth. I didn't put their last name because their last name is actually Farmer, which I thought would be kind of confusing. But these are the folks from the movie Funny Farm. 25 years ago, they bought what they considered to be their dream acreage just outside the city. They were going to put up their dream house, raise horses, and live the rural life. Over 25 years, though, they've realized that the development has caught up with them. There's been suburban sprawl, and now they're facing a situation where they've got to decide whether they're going to hold on to this estate that they've established, develop it themselves, or sell it. And if they're selling, they're going to look for the highest value. Now, these folks are do-it-yourselfer types, so they are not shy to try anything they can on their own to increase the value of the property. Here's a map of the property, and you can see This yellow right here is supposed to be a major roadway. Right here they have another roadway along the eastern boundary of their site. They have a little bit of wetlands down here, but clearly being so close to the suburban sprawl over here, you can see the little lots that have been created for a high-density residential development here. Being so close, they're probably not a good fit for a conservation easement or wetlands banking and that kind of thing. So when they sit down with their team of advisors, let's see, they've got Commonwealth Commercial because they think they might be in a part where they're going to sell. Of course, they partnered with Xenith Bank and JoycePayne partners. And this kind of decision-making requires big guns. So they want to hire the best attorney in town. So they hire Ed Kidd, who's my boss. Is that here? There, okay.
I think you're working on your 401k.
Luckily, I work with Ed, so I get to be part of the team, too. All right, all that aside, what they realize is that they're going to need to rezone their property, and the question is when. I think they realize that with the roadway being up here, there's a chance they could have commercial development on the front, maybe some residential in the back, save a piece for Lawrence down here to put up some nice apartments, and that's going to require rezoning and communication with the county. The problem is, though, is the timing, and I think this is where it's critical to understand where localities are these days in terms of decision-making about the rezoning process. It used to be that you could say, well, this is going to be commercial, this is going to be residential, and that's going to be multifamily, and you run some plans by some folks, and perhaps you get out alive with the rezoning you're looking for. Sidney can attest to how things have changed. We're going to go back to some of his work at Innsbrook just as an illustration. I had a chance to go back and look at some of the proffers that were part of the original 1979 case for Innsbrook, at least for some of the office buildings out there and the shops at Innsbrook, the retail piece. And notice that the topics of proffered conditions that were part of the original rezoning for those properties are generally the same as what we see today. And just as an aside, in case we're not all on the same page, proffered conditions are supposedly voluntary conditions that a developer will agree to as part of rezoning, essentially in exchange for the rezoning. We all know that they're not really voluntary. In many cases, the county will write them for you. But in any event, the topics that were addressed back in 1979 haven't really changed too much. And it makes sense because we've got timing of development, density, use restrictions, buffers. All of these things are intended either to ensure a quality development or to make sure that the infrastructure is in place for the project that's being developed. What I want to do, though, is run quickly through with you proffers from the 1979 rezoning at Innsbrook, a 2004 rezoning at another locality, and then a recent case of what Ed and I ran into recently at another locality, just to show you how things have changed and how counties are expecting more and more. So for the Innsbrook proffers, this relates to the shops at Innsbrook, which is a very successful retail center on the southern end of Innsbrook, right up on Broad Street. And this particular proffer has to do with site design. And I won't read it to you, you can read it yourself, but the 3 points that it makes are that A, the shopping center will not be primarily oriented towards Broad Street. B, it will be a market square pedestrian mall and not a strip center. And C, it will not have its primary access to Broad Street. And for the sake of example today, we'll just set aside that there was probably a master plan involved and people were otherwise on the same page. But for this proffered condition, at least, that was it. That's the direction that the county was giving to the developer, and the developer was obligated to follow at the proffer level with regards to site design. Now, fast forward to 2004, and you can see there's a little bit of a change. The first line here is, the site shall be designed as generally depicted on Exhibit C. Well, already it's different because the proffer specifically mentions Exhibit C. Exhibit C is a layout plan. And it shows generally where the buildings are, where the landscaping is, where the stormwater facilities are, parking areas, et cetera. But it does say generally depicted. So the county is saying, generally speaking, come close to this plan. And then it goes even further to backtrack a bit. It says, however, the exact location of the buildings and parking may be modified, provided the general intent of the plan is maintained. So good. Again, we've got an idea of what's going to go out there. You can shuffle it around a bit, just kind of keep it in the ballpark. Well, today, and a little bit of dramatic effect by putting the whole thing in here, just to show you how specific these things can get. Recently, Ed and I were working on proffer conditions for an office development, and these are again, for illustration's sake, I'm combining some things here, but you can see that there's a lot of discussion of what architecture and what kind of materials and that kind of thing would go into the building itself. The last line is what I want to focus on. It says the development of the property shall be in conformity with the layout plan submitted herewith. Now that's compared to the last slide, which said the site shall be designed as generally depicted. This is not the proffer we ended up with. Obviously, we had to talk with the county about how this wouldn't work. And why wouldn't it work? Well, the development of the property shall be in conformity with the layout plan. Well, what if you need to change your layout plan? The rezoning process is something that is supposed to occur, at least in the natural course of things, a little earlier on than the actual specific planning of the site. The site plan approval comes later. Building permits come later. By agreeing to this kind of proffer, Andy and Elizabeth would be locking themselves in. And that could be in trouble because in a proffered condition, you are changing the zoning ordinance with respect to your property. And the only way you can go back and change this kind of proffered condition, unless you have a very sympathetic zoning administrator, is to go back through the public process. That adds time, that adds cost, and you start to wonder, what is the county or city looking for with respect to this kind of proffer? There have been previous examples shown about about how more general language has resulted in the kind of effect that the county or city is looking for. But nowadays, it seems like they are expecting more specificity, more certainty, so that when they approve a project, they know exactly what's going in place. So it's a trend that we need to be cognizant of, and anybody who's intending to develop real estate should maintain open lines of communication with the county, make sure your timing of development is understood, and just be aware that they'll be asking for specificity at this early stage. Those are my remarks for right now. I'll turn it back over to Sidney.
Thank you very much.